Okay, we're on the record as the people versus Hannah Stark, case 2259101.
Good morning, Your Honor. May it please discern Court Vanessa Moss, P63901, representing Hannah Stark. I wait for appearance before the court today, Your Honor.
Good morning, and I was trying to find her information. Ms. Stark is charged with count 1, stolen property, receiving and concealing a motor vehicle. And is it correct that you want to waive your client's presence for the purpose of setting the preliminary exam today?
Yes, Your Honor.
Okay, and you said she's in custody, correct?
That is correct, Your Honor.
Okay. All right, so we are in February, unfortunately.
Okay.
February 6th, 7th, or 8th, you have any of those days that work for you?
Hold on 1 second, Your Honor. I'm trying to look at my calendar. February 6th, 7th, or 8th. You know what? The 8th will work for me. The 8th is good, Your Honor.
Okay, so we can do 9:30 or we can do 11 o'clock.
Let's see. 9:30.
Okay, and just for the record, the prosecutor isn't here yet. Do you have any discovery issues?
I do not. I have discovery, Your Honor.
Okay, I'll make note of that. Anything else?
What's I gonna ask you? I forgot now, but it slipped my mind.
Okay, well, I'll make on if you remember.
All right. Okay, I will. Thank you. Oh, I know what it is. If she should decide to waive the preliminary exam, do I Zoom in and let the court know ahead of time?
That would be nice, so we could let the prosecutor
Okay,
know.
great. Okay, great.
Yeah.
Okay, great. All right, I will do so. Thank you. Bye-bye.
Thank you. Have a good one.
You too.
Attorney Walred.
Yes, Your Honor.
Good morning.
Good morning.
You have
I have Sink Bearden, Your Honor.
Steve Bearden. Okay. And Mr. Bearden is present. All right.
He is. Veronica Walrad with NDS P85665 on behalf of Sink Bearden.
Okay, let me get the file.
Oh, apologies.
Right, fine. I appreciate you ready to go. Bearden. Okay, we are on the record. This is the people versus Sink Bearden, case 2260926. Mr. Bearden is charged with 1 count of weapons carrying concealed. This is a felony commission with motor vehicle adult advisory. Today's the date set for a probable cause conference. Appearance?
Veronica Walrad with NDS on behalf of Sink Bearden P85665.
And Mr. Bearden, can you unmute your device and state your full name, please?
My name's CQ Rahid Bearden.
Good morning.
Morning.
And Attorney Walrad, I'm calling this case with the assumption that there are no discovery issues where we need the prosecutor present.
Your Honor, digital discovery was delivered last night. I will alert the court if that appears to be incomplete.
I'm sorry, I didn't hear you. Say that one more time.
Digital discovery was delivered last evening. I will alert the prosecutor and the court if it appears to be incomplete. Other than that discovery, there are no issues.
Okay. All right, are you looking to just set a date for an exam?
Yes, Your Honor.
Okay. So we have those same days, the 6th, the 7th, and the 8th. So we can see what time we have available.
I'm all clear so far, so any time would work.
Okay.
For the 8th, judge, we have a time.
How about February 7th at 10:30?
Yes, Your Honor, that would work.
Okay. Mr. Bearden, this will be in person, so you need to be present on February 7th 36th District Court at 10:30.
Okay, thank you.
You're welcome. Anything else, Attorney Walter?
No, Your Honor, thank you.
All right, you all have a good day. Attorney Morton? Oh, wait.
Hello, good morning, Your Honor.
Good morning. How are you doing?
I'm excellent, thank you. I was actually appearing in support of Natalie Johnson and her request for an expungement.
Oh, okay.
Do you have that on your docket this morning?
I do, and I don't know why.
She was on, I think she was on the Samsung phone, and she said she's waiting to be admitted.
Let me see. I do have someone unidentified. So the person with the phone number ending in 1032, can you state your name, please? I'm guessing I sentenced her. That's why I have it. That was on the
No,
tablet?
it was actually sentenced about 6 years ago. I think Izetta Bright was the original judge.
I took her docket, I believe.
Yes.
And I used to do all the expungements until I got on the felony docket. I can handle it.
Judge Sabree,
Actually, if I just have a file.
excuse me, it was all forwarded to Judge Williams.
Attorney Morgan, if I actually have all the paperwork, I can go ahead and sign it as long as the prosecutor doesn't object to it.
Yeah, all the paperwork was sent in and prosecutor received it a few months ago. I don't think there's any objections. It was a pretty straightforward past misdemeanor for OWVI, which is now eligible for expungement. So it should be pretty straightforward.
Okay, give me a moment to find that information,
Okay, appreciate it, Your Honor.
of course, and I will let you know as soon as we get it.
Thank you.
You're welcome. Mr. Williams? Deontay Williams? Go ahead and unmute your
Yes.
mic. Good morning.
Good morning.
Your attorney isn't here yet. I have you checked in. As soon as your attorney gets here, I will call your case, okay?
Okay, thank
Have you talked to your attorney this morning?
you. My last attorney told me that I would be getting somebody new on my last court date, but I never talked to him, or I don't even know who the person is.
Okay. All right, we'll see.
All right, thank you.
Well, Attorney Morton?
Yes, Your Honor.
So I just spoke with Judge Williams' courtroom. They have the information on the file. They said you can log on and they'll hear it as soon as she zooms into that courtroom.
Oh, so it's in Judge Williams' courtroom?
It is, yeah.
Okay, thank you, Your Honor.
Do you need the Zoom information or you?
Yeah, I can log on from the website. Thank you.
Okay, all right, you have a good one.
It's a
You too,
binary.
Bennett.
Ms. Rawlinson, I
It'll be
have you
on
checked in.
Zoom.
Your attorney has not checked in yet. But as soon as your attorney checks in, I'll call your case, okay?
Okay, thank you.
You're welcome. A lot of good dinners today.
Hello.
all the J. Danielle Jones, Michael Johnson,
Yes,
good morning to you both.
good morning.
Well, I have a traffic issue or traffic matters that should be in Judge Williams' courtroom and not in here. It's courtroom 332. Ms. Jones, Mr. Johnson, can you hear me?
Yes,
Okay, I need you to acknowledge that you heard what I said.
I'm sorry, I couldn't really hear.
You're supposed to be in courtroom 332 with Judge Williams, not in my courtroom.
Okay,
Do you need the Zoom information?
okay.
Do you need the Zoom information?
Yes,
Let me know when you're ready. Mr. Johnson, I need you to respond.
yes, I'm ready.
Okay, it's 360-332-0000.
Okay,
Go ahead
thank
and
you.
log on now. You're welcome. Mr. Johnson, you have your hand raised, but you're not responding. Your audio is working. I need you to respond. Okay, Attorney Martin, good morning.
Good morning, Your Honor. Good morning, sir.
Oh, I can barely hear you. I still can't hear you. I can't hear you at all.
Strange. Can you hear me?
I can hear you now, yes. Good morning.
Maybe my finger was covering the mic. I apologize. Yeah, I have a PCC with Selena Rawlinson. May I have a breakout room with her?
Sure.
Thank you.
Ms. Rollinson, you'll get an invitation. If you go into the breakout room, hit join when you see that prompt come onto the screen.
Okay.
Ms. Haydar, good morning.
Good morning. Hi. I'm here on the Cortez Johnson PCC, and defense counsel is Miss Emily New from NDS. She's zooming in now. She's outside of Judge King's courtroom.
Okay, so you just let me know that she's getting ready to zoom in?
Yes, we were just texting now, so she should be zooming in a minute or so.
Okay, we're ready for her.
Okay, thanks.
Thank you. There she is. Attorney New, good morning.
Good morning.
Here, Mr. Johnson, Cortez.
Cortez Johnson, he is.
Oh, it's spelled wrong. Cortez. Okay. Okay, I don't see him logged on yet. Have you spoken to him?
He is in custody. He was being moved. And Miss Hyder, do you remember?
Yeah, so last time we spoke with either it was your clerk judge or it was your clerk supervisor, and they were able to coordinate. We had a phone call, if you recall. There was a three-way call with myself, Miss New, and the clerk. I can't remember her name, but she, I guess, was able to manage to set up the Zoom writ for Mr. Johnson. And I know he was moved custody at one point. He was at Santa Ana County, and then I think he ended up in Midland, I believe it was. And yeah, so my understanding was that he would be zooming in here.
Let's see, I have the writ in the file, and they're supposed to call in at 9 o'clock, so let's just see, give a couple minutes.
Okay.
So it look like we had two downstairs. Had two. Timothy Dewar at 10 o'clock.
At 10 o'clock sharp.
And Keyshawn Williams at 11:30.
I'm sorry. But yeah, he's right next to me.
Hey, Carmen. How you doing? Good morning.
For today?
Timothy Dewar at 10 o'clock.
Work here, so-
And,
Log in at 10 o'clock.
Keyshawn Williams.
They said if you don't log in.
Is that the point?
Yeah.
Okay, so he is zooming in today.
No, we have to zoom into.
To
open
them.
time jail.
I got the, oh, you need to know how to do it, don't you? Okay, I have Leah come over and show them, because I don't zoom into open time. Okay, just these one here, these are my motion predetermined fixes. Remember, don't put Brian, Phil Reagan, or Brandon Brown in the case, because it's gonna look like they are the attorneys on there. So remember, we put their name.
Mr. Barron? And Justin Jackson.
Just make sure. I have.
Yes, ma'am.
Good morning to you both.
Good morning.
I believe you have traffic matters, in Judge Larry Williams courtroom now. We switched dockets, so you need to go to courtroom 332.
332.
Yes.
Thank you, ma'am.
Information, I can give it to you. Do you need the Zoom information?
No, 332 is enough.
Okay, Mr. Jackson,
Yes, ma'am.
you need the Zoom information.
I got it.
I can't hear you.
No, ma'am, I got it.
Okay, all right, you have a good day.
You too.
Docket in our courtroom. Oh, you know what the problem is? 332 is on here. Oh. There it is. I think it's just the notice between old people from the video. Judge, I wouldn't have got it for 5 years. Who's that? In the crowd. Attorney Bradford, good morning.
Good morning, Judge.
How are you today?
I'm doing well. How are you?
Pretty good.
Um,
You are,
I had a PCC scheduled yesterday for Brian Durrell. You gave me until today to try in an attempt to get him here. Unfortunately, I still have not had contact with him.
okay. All right, let me get this file. Thank you. Okay, we're on the record as the people versus Brian Elbert Durrell, case 2355009. Mr. Durrell is charged with 1 count of controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. This is a habitual offender, third offense notice. Appearances?
Good morning, Your Honor. Daniela Birch on behalf of People P85495.
Good morning, Judge, to and your staff. Cody Bradford, P85944, with Neighborhood Defender Service on behalf of Mr. Brian Durrell.
And Mr. Bradford, is it my understanding that your client is still missing or unavailable?
That's correct, Your Honor. Yesterday, we were here for a PCC, and I had indicated the numbers that we had on file were incorrect numbers. You gave me until today to try to contact him. I got an email address. I tried to send an email and contact another number and still have not heard from him. So I have no further explanation beyond that, Judge.
Okay, anything from the people?
Your Honor, people, based on this information and defense's inability to contact them, I believe that Acabius would probably be our best bet here in hopes that we can track them down for defense. So the people would move for Acabius in this manner.
Okay, and I have here in the file that on January 9th it was also adjourned because of not being able to find the defendant. We came back yesterday and Attorney Bradford, you did everything you could, and we are still without Mr. Durrell. So with that, I will issue a case. This would be a personal bond for $1,000 cash, and hopefully you can find your client.
Yes, Judge, I will still make efforts beyond today to find him. Thank you.
You're welcome. You have a good rest of your day.
You too.
Thanks.
Connect your audio. Is it connected?
Mr. Joseph,
Yes,
you are in the wrong courtroom.
I am.
Yes, you're supposed to be with Judge Williams, courtroom 332.
So the last three digits on the front of the screen is 332.
So 360-332-0000.
Okay. Is there? I should search. I should be able to search it like that.
No, that's the Zoom login. You can go on our website and just click on Judge Larry Williams 332, and it'll take you to the Zoom meeting.
Larry Williams.
Yes, 332 Larry Williams.
Okay.
Damon Jackson,
Yes.
good morning.
Good morning.
Same for you. You're supposed to be in Judge Williams' courtroom, 332.
All right.
You need the Zoom information?
No, just go to 332 and you said Larry Williams, right?
Correct, yes.
All right.
All right, I'm good. That's 21 people so far.
I was gonna say, when I went on, if you Google you and 36, it's very apparent, but I don't know if.
I've been there so long on the picture.
Yeah, absolutely.
Ms. Robinson, you want me to, oh, never mind. You're back, okay. Ms. Richards? Nancy Richards?
Good morning, Judge. I have Deontay Williams.
Deontay Williams?
Yes.
Okay, he is here. Mr. Williams, go ahead and unmute your device and start your video.
Hey, how you doing?
I'm fine, how are you, sir?
I'm okay.
As soon as I get filed. Okay, we're on the record. This is the people versus Deontay Williams, case 22-61001. Mr. Williams is charged with one count of weapons carrying concealed today set for a probable cause conference. Appearances?
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Nancy Richards, P68850, appearing on behalf of Mr. Williams, who is present via Zoom.
And Mr. Williams, can you state your full name for the record, please?
Deontay Malik Williams.
All right, are there any issues with discovery?
Your Honor, I am taking this case over from Kirkland, who recently left our office. It looks as though she paper discovery, and I believe we just received some digital this morning, or uploaded this morning. I haven't had a chance to review it yet, but it looks as though we have everything.
Okay, anything else, any preliminary matters?
No, Your Honor, the people would just ask if Ms. Richards, I did send both digital and paper. If after reviewing digital, you feel that there may be some, this is everything that we currently have, but if you feel that there's something missing, just email me directly and we'll get it done.
Great, thank you. I will do that.
Okay, are we ready to set a date for an exam?
Yes, Your Honor.
Okay, clerk is gonna give you your options. Okay, no, the clerk is not. All right, we have February 8th, 9th, 10th, and 13th. Whichever day works best for either party. The times are pretty wide open.
I think the 8th would be the best date.
Okay, we have 9 o'clock, 11 o'clock, and 11:30.
9 would be fine.
Does that work for the people?
Yes, Your Honor, thank you.
February 8th, 9 o'clock in person. All right, I will see you all then.
Thank you. Mr. Williams, I will be in touch. I have a phone number in our system. Have you changed your number recently?
No, it's the 492 number still.
Okay. I think I have. Yes. I'll be in touch.
Okay, thank you.
All right. Thank you.
For the person with the iPhone who just logged in, can you please state your name? Yes, sir, what is your name?
Jose Mauricio Flores.
Oh, Mr.
Interprete
Flores,
the Spanish.
You're supposed to be in courtroom 332 with Judge Larry Williams.
It's not in the Spanish.
I'm sorry, what did you say?
You speak Spanish? Interprete?
No Espanol, no Deborah.
Oh, it's no English.
Un momento.
Okay.
Figure out how to say the numbers and.
I don't know how to. Log off.
I'm the only person I've been with.
I can speak to survive, but not in court. Yeah, prosecutor. Okay, AJ Bosco,
Yes, can you hear me?
I can, good morning.
Good morning.
I just need to make one call to 332 for a Spanish translator, and then I can call your case.
Okay, and that's with Miss Rawlinson?
Yes, do you have another case too?
No, I think that's it.
We got Mr. Flores in here, and he just not speak English. Spanish, interpreter in your approval. Can you have her just call her before bringing, she checks it, so she can tell us. I'm not telling her. Okay. Calling Rawlinson case.
Yes, I'm here.
I've done that. Me too. That's what I want. It's just like that.
Okay, this is People versus Selena Rawlinson, case 2162051.
Good morning. Okay, that's how you do it. Good morning. I said you can't go over and say, hey, I'm
You're talking to your friend.
Good morning. Pardon for the.
I'm muting you just for a second, Mr. Martin. Ms. Rawlinson is defendant number one in charge with count one, false pretenses, $1,000 or more, but less than $20,000. And count two, fraud, obtaining signature with intent to defraud. Today is the date set for a probable cause conference appearances.
Good morning, Your Honor. Abigail Bosco on behalf of the people, P number 82893.
And good morning, Judge. Neighborhood Defender Service of Detroit, Carrie Martin, P84592, appearing on behalf of Ms. Selena Rawlinson. Ms. Rawlinson, would you please state your full name?
Selena Rawlinson.
Everybody, they set for a probable cause conference. Are there any discovery issues?
Well, Judge, this case
go ahead.
wasn't assigned as far as I could tell as of yesterday, so I have not sent discovery to anyone because I didn't know who to send it to. So I think as long as the defense is okay, I'd request just another PCC date. Give us some time to get discovery.
Yes, that works for us.
Okay. We're in February for exam days. There's an issue with setting exam date and you all getting your discovery or getting that matter handled and setting exam date? Or the setting exam?
I'm comfortable with an exam date as long as there's a discovery deadline a few days beforehand.
Okay, Prosecutor Bosco, how long do you think it'll take for you to provide discovery to Mr. Martin?
I can get discovery to him by tomorrow.
Okay. So we're in February 8th, 9th, 10th for exam dates. And I'll set the deadline for like the 25th for discovery. to be
Is
provided.
there any way we could do the exam the week of February 13th?
And the
I'm out of the office the 9th and 10th.
How about 13th?
The Monday, the 13th?
Yes.
Yes. That works for me, Judge.
For the people, Your Honor.
Okay, so anything after 9 o'clock, between 9 o'clock and 11:30, it's you all's choice.
Can we do 11:30?
All right. And I'll put in the file discovery to be provided by January 25th.
No problem, Your Honor.
Thank you, Your Honor.
All right, so Ms. Rollinson, your preliminary exam will be, not right now, February 13th at 11:30 a.m. in person.
I'm sorry, February 13th at 11:30 a.m. in person?
Correct.
Okay.
All right, anything else?
Nothing from the people, Your Honor.
Okay. Mr. Martin, I have 2 exams on here scheduled for you. Are you coming in for those 2 exams?
I am. I have 5 exams this morning. I'll be right in.
Okay, all right. Drop that, Ms. Robinson. You can contact Mr. Martin.
I have a quick, this can't be on Zoom.
You can talk to Mr. Martin, your attorney, about whether you want to proceed on Zoom or in person.
Okay, sounds good. Thank you.
I'll follow up soon, Ms. Rollinson.
Okay, thank you.
All right, take care.
Have a good one, Ms. Bosco. Okay. That's the first page. I can't tell. I want to listen. He's not paying attention. I can't. Mr. Flores,
Yep.
Ms. Sonic, can you check your messages?
Mm-hmm.
Sometimes they do it on phone, but I don't know.
He's on the phone to do his court case. Right, so that he's on the actual plan. So I just. He's in violent issue.
Okay, we can do this next.
Yeah. Are you gonna do it before 1:30?
That depends on, she wants to go without.
Okay, thank you. Okay, thank you. Okay, bye-bye.
Okay, I'm getting ready to post it on the page. I'm sorry, there's no interpreter.
Oh, wait, Judge Sabree. Okay, I mean, Judge Sabree. Okay.
Actually, she can do it. Mr. Flores,
Yeah. Okay, thank you.
you're welcome.
Okay.
This Travis is fantastic, you know.
Great job.
Oh, wait, how to do it. Yeah. She does have it on the table. Right, she does that. They will report the- Yeah. So can we get the info for my Oakland County Jail? For Zoom information?
No, leave us not come over. 10 o'clock.
We
Probably should have it come to 9.
we don't have one on
What about this time?
Terrence Williams didn't show
I
up.
didn't say anything.
1:30. You can do it now?
Terrence Williams.
With Mark.
Good morning to the gentleman, the Wayne County Jail. Please state your first and last name, please.
Good morning, Your Honor. Kareem Walker.
You said Walker?
Yes.
Kareem Walker, okay. You have a bond redetermination hearing. Your attorney is not present as of yet. Let's see. We're gonna give him or her a call, see if they can log on.
Okay.
Hold tight, Mr. Walker. I'm gonna put you on mute until we talk to your lawyer.
Okay.
Your Honor.
Yep, I'm here. Good morning.
Good morning. Mr. Reagan is going to zoom in for the bond redetermination hearing.
Thank you.
You're welcome.
It's not over here.
It's already been a morning.
I heard something in the background over there, Frankfurt. Or were you at Frankfurt?
Not yet, but I'll be there later. I'm in, I have 5 exams between you, Jefferson, and Jones.
Okay, well, let's get moving. Okay, we're on the record as the People versus Terrence Deshaun Williams, case 2260969. Mr. Williams is charged with 1 count of false report of a felony. Today's the date set for a preliminary examination. Appearances.
Morning, Your Honor. Daniela Parrish on behalf of the People, P85495.
Good morning, Judge, Neighborhood Defender Service of Detroit, by Carrie Martin, P84592, appearing on behalf of Mr. Williams. Mr. Williams, would you please state your full name?
Terry Deshaun Williams Jr.
Good morning, everybody. And our people are, I should say, are both parties ready to proceed?
Your Honor, my apologies. People are unable to proceed at this time. Our necessary witness that was subpoenaed on December 28th still to appear.
Motion for dismissal.
Okay, without the people ready to proceed, I will dismiss without prejudice. Your Honor, Mr. Williams, will take this business. We're ready to go already. Eric Finley.
Yes, good morning, Your Honor.
Good morning, how are you, sir?
I'm doing well, and yourself?
Pretty good. I think you're in the wrong courtroom. Are you here for a traffic matter today?
Actually, Your Honor, I'm here in regards of some traffic tickets I received. I was supposed to come to court, but when I came to court, you guys had an issue with the Zoom, and everyone had to evacuate the building. And I never received a reschedule.
Okay, so call, so you're in the wrong courtroom. I'm not on traffic anymore. So it'll be with Judge Williams, Larry Williams. You can zoom into the courtroom 332. Let me know if you need the Zoom information, and I'm going to give you the courtroom number to speak to the clerk to see when your date is. If you need to get a court.
Okay. Sorry for the noise, Your Honor. So you said Judge Williams?
Larry Williams, yes, courtroom 332.
Thank you very much.
But also, if you want to take the number down, you can call the clerk to get a date if you don't have one.
Yes, Your Honor. I'm ready for the number.
313.
I'm ready.
965 2285.
Okay.
And let the clerk know about that. I remember that day where everyone had to evacuate. Let them know that's the day you had your court date scheduled.
Okay. Thank you, Your Honor.
You're welcome. Have a good day.
You too.
Attorney New?
Yes.
I'm sorry, I don't have anything for you. I don't have anything for you. I just thought you were on in custody, gentleman, Mr. Walker, but you're not. You're only on this-
That's
Okay.
correct, just Cortez Johnson.
Okay, we're still waiting.
Okay.
Attorney New, we actually have Mr. Johnson on the phone.
Oh, I'm right outside the courtroom. Would it be easier if I came in?
Yeah, come on in.
Okay.
Yeah. She's on Cortez, instead of Cortez.
Okay. Yeah, there's,
Okay. So did you get everyone that we did? Because I know.
yes, Your Honor, thank you. We're on record, right?
Mr. is this Steinhill?
Yes.
Good morning.
Good morning.
What are you here for today? Oh, I see you have an exam at 10 o'clock.
So we'll talk this one more, that's when I have a.
Did your attorney tell you to zoom in?
No, ma'am. I think I gotta be to court at 10. That's why I zoomed in.
You need to be in person for this.
What'd you say?
You need to be in person for this.
Yeah, I will.
Oh, we gotta meet in person?
Yes. If you're gonna have a preliminary exam, you need to be in person.
Okay, he didn't tell me.
So call your attorney first and let me know, if you all have arranged to do it on Zoom, that's fine. But contact your attorney first, because otherwise you need to be in person for this.
Okay, thank you. I'm about to call him.
So log off, call him and call back and let me know what you guys plan on doing, okay?
Okay, thank you.
You're welcome. Attorney Jordan, good morning.
Good morning, Your Honor.
How are you today?
I'm well, thank you. And yourself?
Pretty good. Who do you have today?
Your Honor, I have two people. I don't know if you got a call from I believe it was your clerk I spoke to. I'm in trial in front of Judge Cox, and I have two preliminaries before you at 11 and 11:30. So I believe it was your clerk said that perhaps I should get another date. Although I can tell you, Your Honor, I think that we'll be doing closing arguments. We'll probably be done around noon with this case, as far as proofs.
All right, let's see here. Are these your cases or they're yours?
Yeah, Dickens and Williams.
It's Dickens and Williams, correct?
Yes, Dickens and Williams.
Okay, let me just pause here.
Your Honor, so, do you know when we're gonna adjourn, or because I know what the second one, we've got, I did speak to the victim, they're all gonna be coming, so if I could reach out to them, try to stop them from wasting their time coming down, I'm happy to do so. Do we know when we'll be adjourning it to? Or if we put in a date temporarily?
I'm free next week, Madam Clerk and Your Honor. Oh, I'm sorry, that was the prosecutor speaking. I'm free next week.
We could, I have no objection since you are in trial. The only thing is, I could set something up tentatively, sir, but if for some reason, once I call the victims off and the witnesses on the other case, if for some reason there's an issue with the date, I may need to come back later on and set a different date if that's okay with you.
Oh, if you're asking me, of course, you're being very, very patient with me, and I appreciate it.
Let me call the case. Miss Vivian, good morning. Before I call these cases, I want to let you know.
Okay, good morning. I'm here for Flores,
I was
Mauricio.
able to I used Google Translate and I put it on the screen to let him know to go to 332. So he understood that. So.
Oh, okay. So you want me to go there now then?
Yeah, she's in 332.
Okay, great. Thank you.
You're welcome. Okay, let me get.
She's on.
Williams
Yeah, you can
and
call him. Okay. The sheet's here, right?
We're on the record with the people versus Gabriel Dickens, case 2260749. Mr. Dickens is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, ammunition, possession by a felon. Count 3, weapons, carrying concealed. Count 4, weapons, felony firearms, second offense notice. Count 5, weapons, felony firearms, second offense notice. This is the habitual offender, third offense notice. Also, Sean Demetrius Williams, case 2260947. Mr. Williams is charged with the following. Count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons, firearms, discharged from a vehicle. Count 4, assault with a dangerous weapon, felonious assault. Count 5, carrying concealed. Count 6, police officer fleeing, third degree vehicle code. Count 7, weapons, felony firearm. Counts 8, 9, and 10, also weapons, felony firearms. Set both cases for a preliminary exam today at 11 o'clock and 11:30. Appearances?
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Attorney Carl Jordan, P number 57226, appearing by Zoom on behalf of Mr. Dickens and also on behalf of Mr. Williams, Your Honor. I don't believe Mr. Dickens is present at the moment. He will be arriving later on this morning. And as far as Mr. Williams, he is in custody. I would waive both of their appearances since we are just setting dates, Your Honor.
Okay, I will allow for the waiver of both appearances for the purpose of adjourning, I believe, that we're gonna adjourn both cases.
Your Honor, this adjournment is at my request. It should be on the record as my request, and I apologize to you and to Madam Prosecutor. I would have given you a heads up that I was going to be in trial, but my trial was spun. I did not know that I was actually going to be in trial. And even then, we thought it would be completed by this time. So I did not want to call off the preliminary examination when I thought I might be free. But if Madam Prosecutor is kind enough to give me another date, and if the court is as well, I would greatly appreciate that. Thank you, Your Honor.
No objections from the people, Your Honor, based on the circumstances and defense being subject to trial.
Okay, I heard discussion of next week.
Yes, Your Honor, if you have something open, as I said off the record, the people are happy to adjourn it to the court's next available date. Defense indicated their availability is next week. I would just like to know that after I call the witnesses, both officers and civilian witnesses, if by chance there is an issue with the date we set today, I will come back to the court by tomorrow to set it for a different date. But if we could get the first available that works for defense, that's fine with me.
And Your Honor, I only said next week because I thought the court might want to do it quickly, but I certainly am not pushing for next week. Whatever date the court gives us is fine.
Well, I do want to get this taken care of. So I'm going to squeeze you all in. I have 10:30 available on the 24th.
That works for me, Your Honor.
And just be patient with us on that day.
Oh, as you've been with me, of course, Your Honor. Thank you.
Okay, so both cases will be scheduled for 10:30, and you all can pick which cases to start with.
Thank you, Your Honor. Thank you, Madam Prosecutor.
Thank you. Have a good day.
Your Honor, I will contact Mr. Dickens, although he might show up. Obviously, if he does, the court will let him know the new date. Thank you, Judge.
You have a good one. Thank you. All right. Speak, Mr. Johnson. Want to go on the record? Mr. Johnson?
What time?
Okay, one more time, Mr. Johnson, can you say something so we can hear you? Okay, yes, can you hear us? Okay, so I'm getting ready to call your case. I want you to be able to hear. If you have problems hearing, please speak up and say something and I'll repeat, okay? Sure. Okay. Cortez. Okay, we're on the record as the people versus Cortez Johnson, case 2260390. Mr. Johnson is charged with 1 count of stolen property, receiving and concealing motor vehicle. This is a habitual offender second offense notice. Today is the date set for a probable cause conference appearances.
Good morning, Rhonda Hadar for the people, P84161.
Good morning, Your Honor. Neighborhood Defender Service by way of Emily Yin, my number is 85234 on behalf of Cortez Johnson.
And Mr. Johnson, can you state your name for the record? Okay, and for the record, Mr. Johnson is on the telephone. He is not on Zoom. And Mr. Johnson has been instructed to speak up if there's anything that he cannot hear throughout this hearing. And today is the date for a probable cause conference. Are there any discovery issues?
No, Your Honor.
No, Judge, people have turned over all discovery.
Okay, yeah, Any other preliminary matters that need to be discussed today?
Nothing for the people.
We would like to set an exam day, and I guess we should discuss how Mr. Johnson will be able to.
Okay, Mr. Johnson, the prosecutor and your attorney are discussing a date for your preliminary exam.
Okay, but I couldn't do it. I got a question anyway, right?
If you have a question for your attorney, then you need to ask that privately, not on the record.
Yeah, but I couldn't do what I was saying.
I just told you, they're discussing a date, they haven't even given a date yet.
Judge, does Friday the 17th February work?
So Mr. Johnson, the prosecutor just asked if February 17th was a good date for everybody.
That is a good date for me.
Mr. Johnson, it wasn't a question to you, I'm just repeating so you know what was said, because you said you couldn't hear. Just tell me what
And
was
then
said.
I'm sorry, is it possible to do it in the afternoon? I have trial every week of February, but I should be done by that Friday and certainly by the afternoon. So I'm just wondering if there's any way this could be like a 1 p.m. exam if possible.
It would have to be 1:30 so staff can have a break.
Okay, thank you.
What day did you say?
Friday, it's February 17th, 2/17.
Okay, I won't be here.
Okay.
If you just want that date, that's fine.
Will there be a judge that will be able to hear the case?
Yes, it'll be a judgment.
Oh, okay, got it.
That's fine. Okay, so we'll do February 17th at 1:30.
Thank you.
Johnson be brought in person.
Mr. Johnson, did you hear that date? At 1:30, and we're going to, your attorney just asked if you can be brought in. What we'll do, the court will, what we call a writ, we'll have a writ issued to your facility so that you can be brought over in person for your, okay? Mr. Johnson, that's a question you talk to your attorney about. You have a right to have a preliminary exam in person, and if you want to waive that right, then you have to talk to your attorney about that, and you have to be very, very careful about waiving that right. So talk to your attorney about that, okay? All right. Anything else?
No, Your Honor.
Okay, so
Nothing for people.
Mr. Johnson, I will see you on February 17th at 1:30, and it will likely be in person, but talk to your attorney about that, okay? He said, what's my attorney?
Emily.
Emily New.
I'm gonna call him. I'm trying to set up a call today.
Okay, she said she's gonna call you today, or try to set up a call today for you, okay? I got her. Yes, she said she's already done. You're welcome. I'm gonna hang up now. You have a good day.
Thank you, Judge.
All right. That's it. 17. Okay, it's 10 o'clock. You ready to call in the overtime? Mr. Tank, while we're waiting, we have a quick moment. Good morning.
Good morning.
How are you today?
I'm good. I'm here with Mr. Stodgel on Zoom because after talking with him, Your Honor, it's our desire to waive the preliminary examination today, and I didn't think that would be an issue.
It's not an issue, and I'm glad, I had to call you to make sure that I didn't know what the plan was, so this works out. As
Okay.
soon as Ms. Parrish comes back into the courtroom, I'll call the matter and put the waiver on the record.
Okay, thank you.
And I'll put it on the record, so she doesn't have to.
Okay.
Attorney Tank, I'm getting an okay from the prosecutor since she's in the hallway. Attorney Reagan, good morning.
Hey, Judge, good morning to you and your staff. How are you?
I'm fine, we're busy, but we're okay, we're moving. Are you here on Mr. Walker by any chance?
Yes, Your Honor. Mr. Kareem Walker.
Yes.
Yes.
Can you talk to him?
If I could briefly, Judge.
Okay, that'll give us a chance to do a waiver and then we'll get back on the record.
Thank you.
Okay, Mr. Walker, you have to hit join on your screen when it pops up to, go into breakout room so you can speak to your attorney in private, okay?
Okay.
Okay, you were the only one on Zoom, I believe, they told me to come in, or did you already take care of that? No, okay.
Timothy.
Okay, we're on the record. This is the people versus Charles Stockhill, case 22-60597. Mr. Stockhill is charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 2, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. The habitual offender's second offense notice. Today is the day set for a preliminary examination. Appearances. Morning, Honor Daniela Parrish on behalf of the people, P85495.
And my name is Craig Tank, and I appear on behalf of Mr. Stodchill. My bar number is P58360.
And Mr. Stockhill, can you state your name for the record, please?
Did you hear me now?
No, I didn't. You were, go ahead.
Could you hear me, Charles Stodchill?
Thank you. Good morning.
Good morning.
It's my understanding, Attorney Tank, that your client is wishing to waive his preliminary exam today.
He is, Your Honor.
Okay. Mr. Stockhill, I'm gonna have to ask you a couple questions, okay?
Yes, ma'am.
And you understand you have a right to a preliminary exam?
Yes, ma'am.
And do you understand by waiving your right to a preliminary exam today, that means the prosecutor does not have to call witnesses?
Yes, ma'am.
And you also understand that that means that the prosecutor does not have to prove at the probable cause standard that you committed the crimes that I read out today on the information, and that that crime was committed in the city of Detroit.
Yes, ma'am.
And knowing that information, do you wish to still waive your preliminary exam?
Yes, ma'am.
Okay, so I find your waiver to be freely, understandingly, and voluntarily given, so I will have you bound over to Third Circuit Court, Frank Murphy Hall of Justice, and your arraignment on the information date will be February 1st at 9:00 a.m.
Okay, thank you.
And
Thank you, ma'am.
counsel, do I have your permission to sign your name on the waiver form?
You certainly do. And just to clarify, you said February,
February 1.
February 1st. Okay, thank you very much.
And also, on the record, can you also say that you all waive your presence and your are okay with on Zoom for this hearing?
Yes, we have no objection to appearing on Zoom, and you have permission to sign my name, and thank you.
Okay. All right, anything else from the parties?
Nothing.
Okay, you're all set, Mr. Stodgill.
Thank you.
Thank you.
You're welcome. Have a good one.
We have both Turner and Dewar. Yes, Turner and Dewar.
Okay, before we do that, we had a 10 o'clock call, we're supposed to call in.
Which one is that?
That's on Mr.
That one, is that the Turner one, Your Honor?
No, Eddie Flynn.
Pardon me?
Eddie Flynn.
Oh, that is not my case, that's an AG case, Your
And
Honor.
he's logged on.
Okay.
Here. That's not the person. I'm trying to. Okay, Attorney Phelps. You're on Mr. White, correct?
Yes, Judge.
Counsel here on Eddie Flint? The defense counsel here on Eddie Flint. Good morning.
Hi, good morning.
Okay, so you're on.
Timothy Turner, Your Honor.
Turner.
945 for example.
Oh, okay. Nice. Let's handle those. Wow. And you're on Mr. Dewar? Yes. Attorney Harris, they're still grabbing Mr. Flint.
Okay.
Okay, this is People versus Timothy Turner, case number 2260428. Turner is charged with one count of weapons carrying concealed. Today's set for a preliminary exam. Appearances.
Good morning, Your Honor. Danielle Parrish on behalf of People PA 5195.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P 86151, appearing on behalf of Mr. Turner.
Hey, and are both parties ready to proceed with the exam?
Your Honor, my apologies. I've been informed by the court officers that none of our witnesses who were subpoenaed on December 16th have appeared. Therefore, the people are unable to proceed at this time without our witnesses.
Any further defense?
Your Honor, I'm moving to dismiss or have no objection to a dismissal in this matter. And I am asking to waive Mr. Turner's appearance as he is currently in the Oakland County.
I'm sure he doesn't mind.
Not at
being
all.
Here for this. Okay, so I'll waive his presence, and since the people are not ready to proceed, I will dismiss without prejudice.
Thank you very much, Your Honor.
You're welcome. Thank you for your patience. You have a busy day.
No problem.
Anything else from the party?
Nothing from the people. Thank you, Your Honor.
Nothing for the defense, Your Honor. Thank you.
Thank you. I have the form somewhere around here ready to be signed or to be passed out.
I think it's been provided.
Turner.
You might have got it.
I'm doing it now.
Oh, okay, perfect.
Okay, you are.
That right there, come up with my partner.
Wagner. we're on the record in the people versus Timothy Dewar, case 2260205. Mr. Dewar is charged with 1 count of jail, prisoner possessing contraband in the habitual offender court. Offense notice today is the day set for a preliminary examination appearances.
Morning, Your Honor, Danielle, Sarah, County Investigation 85495.
Good morning, Your Honor. Neighborhood Defender Service by Summer Source, number 85828. Hearing on behalf of Mr. Stewart, who is present in the courtroom today.
And Mr. Dewar, can you state your name for the record, please?
Timothy Andrew Dewar.
Good morning to everybody. And today is set for a preliminary exam. Our parties ready to proceed.
Your Honor, my apologies at this time. The officers that were subpoenaed have failed to appear, and people are unable to proceed without them.
Anything from defense?
Your Honor, we move to dismiss at this time.
Okay, since the people are not ready to proceed, the time is now 10:17. The exam is scheduled for 10 o'clock. I will dismiss without prejudice, and your case is dismissed, sir.
Thank you, ma'am.
All right, you're welcome. Anything else from either party?
No, Your Honor.
Okay.
It's a good. Okay.
Like, for now.
Thank you.
Okay, we're gonna call Mr. Eddie Flint next. Mr. Flint, can you hear us?
Yes.
Okay, we're on the record. This is the people versus Eddie Flint. Case number 2257969. Mr. Flint is charged with 1 count of gambling activity, felony violations, and also case number 2257968. And Mr. Flint is charged in this case with same charge, 1 count of gambling activities, felony violation. Today is the date set for a probable cause conference on both cases, appearances.
Good morning, Your Honor. Robert Hayes, Assistant Attorney General, here for the people, P69006.
Good morning, Your Honor. Wyatt Harris, P54891, on behalf of Mr. Flynn on both matters.
And Mr. Flint, can you state your full name for the record, please?
Eddie Andrew Flint.
Speak up a little bit louder. We can barely hear you.
Eddie Andrew Flint.
Thank you. And today's the date set for the probable cause conference. Are there any issues with discovery?
Your Honor, I received discovery last week. I have not had a chance to go over it with Mr. Flint. I anticipate going over with him soon, making a jail visit with him. And so I guess what I'd be asking, and I leave it to the court's discretion, if you wanted to do another PCC so we could make a determination as to whether we're going to hold the exam or not.
Attorney Harris, because it was so difficult to get Mr. Flint on Zoom, I would like to, we're in the second week of February for a preliminary exam anyway. So I would like to just set it for an exam, and if for some reason there's a waiver, we can schedule a date before that.
Okay.
Does that sound okay?
That's fine, Judge.
Okay.
Your
So-
Honor, I'm sorry not to interrupt, but
Oh,
if
okay.
you could
Sorry.
potentially inquire as to what Mr. Flint's current situation is and his holds, and I'm unsure of where he stands right now and what his situation is, and perhaps that would help move towards resolution.
As far as with Oakland County or just?
As far as Oakland County, and if he has anything else that he's aware of going on.
Well, Judge, I would not want Mr. Flint to make any statements with regards to what he is being charged with or what have you.
That's fine.
Let me have a conversation with Mr. Hayes, and then I can communicate with you if there's a way to resolve this short of it. having an exam.
Okay. All right, so, I have February 8th, 9th, 10th, and 13th as the earliest date to open.
Your Honor, if I had to pick, the 9th would be ideal, but I can make other things work.
The 9th in the morning would be fine for me, Your Honor.
Okay, I have 9 o'clock, 9:30, 11, or 11:30.
Judge, why don't we make it about 11?
That work for you, Attorney Hayes?
Yes, thank you, Your Honor.
Okay, so the exam has been set for February 9th at 11 a.m. And for some reason, Attorney Harris, if we need to have him read it or not read it, it won't be read. Have him scheduled for a Zoom call prior to, just call the court and we can do that.
Thank you very much, Your Honor.
And we'll also issue the writ for the preliminary exam date for February 9th.
Thank you.
Okay, anything else?
Thank you, Your Honor.
Nothing further.
Okay, you all have a good rest of your day.
Thank you.
You're all set, Mr. Flint. Attorney Harris will give you any details or answer any questions you may have, okay?
I got court here on February 7th. So you're gonna make the written after February 7th?
Yes, we scheduled it for February 9th.
All right,
What do you have scheduled? Is it a trial or is it a pre-trial?
pre-trial.
Okay, all right, so the 9th, we will see you at 11 o'clock at 36th District Court.
Okay.
Your Honor, is it possible you could place me in a breakout room briefly with Mr. Flint?
Sure. Mr. Flint, I need you to hit join so that you can speak to your attorney in private. It should pop up in about 5 seconds or so. Then you can ask any questions you may have to your attorney, okay?
All right.
It should pop up now. Okay. Let's handle Mr. Walker. You already did it.
Karen, we haven't handled light yet, correct?
We have not. I'm okay. Waiting till we get done with the other custody gentlemen, and then we're gonna handle the right. Okay, this is the people versus Kareem Amin Hayes Walker, case 2355200. Mr. Walker's charged count 1, home invasion, first degree, count 2, police officer assaulting, resisting, and obstructing. Count 3, domestic violence. This is an habitual offender, third offense notice. Today, the date set for a bond redetermination hearing. Appearances.
Morning, Honor, Daniela Parrish on behalf of people P85495.
Yes, I had to ask if Attorney Reagan was ready to go. Attorney Reagan, you must be on the record. If you're available, can you unmute and put your name on the record? Okay, we will recall your matter, Mr. Walker, as soon as Attorney Reagan, I believe he's on the record, as soon as he's off the record and lets us know, we'll recall your matter.
No, Your Honor.
You want to have the light down?
Sure, yeah.
Oh, wait, we have Attorney Reagan. Let me handle this, before we start, Mr. White. Okay, Attorney Reagan, I just put the case on the record. Can you put your appearance on, please?
I'm sorry, Your Honor. May it please this honorable court, Philip Reagan, 57156 on behalf of Kareem Walker, who's appearing via Zoom.
And Mr. Walker, can you state your full name for the record?
Kareem, middle name as well?
Yes, your whole name.
Okay, Kareem Amin Haynes Walker.
Thank you. And today's the date set for the bond redetermination hearing, whenever you're ready, Attorney Reagan.
Thank you, Your Honor. Judge, on a previous date, actually January 16th, Mr. Walker was given an unaffordable bond of $750,000 cash by a magistrate of this court, Your Honor. Judge, just to give you a little bit of history about Mr. Walker, he's 34 years of age, Judge. He's gainfully employed. He has 2 jobs, Your Honor. He works at Flex Warehouse, doing shipping and receiving, and he also works at Thyssen Crump, which is a job he goes to after he finishes that job. He has 2 children, Judge, 12 years old and 10 years old, that he supports. He's a lifelong resident of this area. Now, I feel that the bond, Judge, is excessive. Now, looking at the charges, Judge, Mr. Walker and his wife were celebrating his birthday, having a birthday weekend celebration. They had just gone out to have dinner, and unfortunately, things weren't as peachy afterwards. They were drinking. They went to pick the kids up at his mother-in-law's house, and they got into an argument, Judge. Now, I looked at Mr. Walker's face. He doesn't remember a whole lot. But what I will say, Judge, is that this is not necessarily in his character. I think that this is, if it happened the way in which the investigators reports said it happened, it's isolated. I don't think he home invaded anybody's house. I don't think he went in the house. According to him, everything happened outside of the house. The kids were actually inside of the house. And I basically told him, Judge, that, you have to make better decisions as a grown man in terms of how you deal with situations, you and your significant other, Judge, because you got kids involved. At worst, Judge, I think that if this matter were to go across the street, I mean, he would not be looking at going to prison or jail, Judge, based on what I know from what he tells me. So I'm asking the court, Judge, to reduce this bond. I think it's excessive. $750,000 cash is really obsessive. I'm asking for a personal bond with a GPS tether, Judge, so you can monitor his whereabouts. You tell him to have no contact right now. While this case is going on, he will have no contact with the young woman. I just want him to be able to go to work. He has 2 jobs. He supports his family. I don't want him to lose his jobs because he's sitting in jail, Judge, on a bond that he cannot afford.
Anything from the people?
Yes, Your Honor. People would object to any bond reduction and specifically a personal bond in this matter. Regardless of course, everybody is innocent until proven guilty. We understand that. So regardless of what results, these charges are significant, including allegations of violence. On top of that, we have resisting and obstructing an officer. Again, regardless of how it came to be, or if it's an isolated incident, these are serious charges for the safety of not only the victim, but the community. People believe that it would be inappropriate to grant a personal bond in this situation. However, if the judges in court is so inclined to reduce the bond, again, the people would request that it not be a personal bond, and that the tether is required with severe and serious restrictions. I would prefer objecting to any bond reduction at this time, and possibly just ordering a DSU report between now and the exam.
Okay, based off of information I have before me, Mr. Walker's criminal history, the nature of the case, the charges, alcohol involved, children, domestic violence. Most I will do, I don't feel comfortable with Mr. Walker being out on a personal bond. What I would do is I will order a DSU so that when he comes back to court, I will have better information, and I will add surety to the cash bond. But that's all I'm going to do at this point.
Judge, would you consider like 75,000, 10%, something that he could possibly post, if he could post it, I don't know. But I just don't want him to lose his job. He's not due back before you until the 24th, which is a week, Judge, and he may be unemployed by then. I know, Judge, this is probably going to end up, and I'm not saying that whether or not that she even shows up. I mean, it's a domestic situation, it's serious, and I don't want to make it seem like it's not serious. But these cases, Judge, I think will resolve themselves once you hear the evidence, Judge, at the exam, if you even have an exam. I mean, but I just don't want to see him lose his job because of he can't post a bond, Judge. $750,000 cash is that's like a remand.
I said I would add surety on it,
Okay, thank you, Judge.
and I'll order a DSU report, and it
Thank
should be
you,
ready by the time he comes back to court.
Your Honor, the people would know that, I have not read every detail of this, of the report, but from what it appears, and defense can correct me if I'm wrong, this seems like this is a domestic issue, and if that is the case, our courtroom will likely not hold the exam, and it would be transferred to Judge King to the domestic violence unit there.
That's correct. Yeah, and Judge, I saw the charge, count 3 is DV, and I thought it was odd that it was in your courtroom, because I know Judge King does all the domestic cases.
We do bond often, defense counsel, often we do bond redeterminations for other courtrooms. And
Okay.
more often than not, as you know, we sometimes receive cases that are DV and not recognized immediately as DV due to the other charges
Gotcha.
coming for first. But if that is the case, I will reach out to DV and it'll likely be after this bond redetermination. If we don't catch it before the PCC, we'll have it transferred over at the PCC to Judge King.
Thank you so much.
Okay, anything else?
Any further thank you.
Not on this case. Thank you, Your Honor.
Do you have another case, Attorney Reagan?
Judge, I have a capious I wanted to ask you about. Somebody's getting arraigned today. They missed court last year. They were in the hospital. They informed us they were in the hospital and they were given a bond. Actually, it was Judge King's bond, but it's your case now. It's your case now. It's coming back to you for exam. But I was going to try to see if there was any way we could get a personal bond.
What's the defendant's name?
You know what? And she just walked in here and she took the sheet right off of my desk, and I apologize, Judge.
Fine, we're here.
Okay. Thank you, Your Honor.
You call it. You're welcome.
Thank you so much.
You're welcome. And Mr. Walker, I'm gonna log you off. Okay. Now, Mr. White, that would be correct.
I know defense counsel, Martin, like I said, and he was kind of pulled in a couple different directions. I'm not sure if they were waiving or still holding on the Miller case, so I'll come out and find out. Okay, you have all of our officers have been here for a while.
Okay. And did you have the motion up for Mr. White, right?
Good, well, I know when to respond.
Okay.
We can call that if you want, Your Honor, get that off your docket.
Okay, let's do that. Waiting, you're waiting.
Okay.
Okay, this is People versus Henry Light, case 09-65969. Mr. Light is charged with count 1, robbery armed, count 2, assault with intent to rob or armed, count 3, weapons, felony firearm. Today's set for a motion hearing.
Morning, Your Honor, Daniela Parrish on behalf of the People P85495.
And good morning, Your Honor, Neighbor Defender Service of Detroit by Natalie Phelps, P83355, appearing on behalf of Mr. Henry Light, who's also present via Zoom. Mr. Light, can you unmute yourself and state your name for the record, please? Maybe he can't hear us.
Mr. Light, can you unmute your device? Mr. Light? Mr. Light? It's unmuted. He's unmuted. I don't know what's going on.
Mr. Light.
Let me send a message through. I don't think he can see either.
Huh.
I'm not sure what to do at this point, Mr. Light. Let's see.
Your Honor, if the prosecutor's still in there, I mean, I'd waive his appearance for the purpose of the motion hearing.
Okay, Mr. Flint, your case has been taken care of. You're all set. I'm gonna log you off, okay?
Okay,
All right, you have a good rest of your day, Mr. Flint.
you too, man.
Thank you. The prosecutor stepped out. When she comes back in, I'll put it on the record.
Okay, thank you, Judge.
Okay, thank you. Hello.
No, because it's really easy.
Attorney Woodside, we're getting ready to start a motion hearing. Do you want to waive your client's presence for this very quick hearing?
Good morning, Judge. I was trying to get Ms. Harris on the Zoom. I have her on the phone. I can waive her presence if the court would allow.
Yes, for this matter, yes.
Just hold on, Ms. Harris. You'll hear the proceedings.
Okay. And I can actually hear her too, so she can put her name on the record.
Okay. Good morning, Honor. May it please this honorable court. Sharon Clark Woodside appearing on behalf of with Ms. Kirsten Harris, who is an officer of the court. I am stating is on my phone and she can hear the court proceedings. Ms. Harris, can you put your name on the record? Did you hear that, Judge?
I did.
Okay.
And for the record, this is case 2261003, the people versus Kirsten Harris. Ms. Harris is charged with count 1, assault intent to murder, count 2, weapons, felony, firearm. And for the people, parents.
Morning, Honor. Daniela Parrish on behalf of people, P85495.
And exam is scheduled for 1:30 p.m. today. However, I received information regarding this case. Ms. Parrish, you could elaborate.
Yes, Your Honor. And I believe defense and the defendant have agreed to waive their presence and have this hearing on Zoom where the people do not object to that. I do want to detail. On this case, we have a complaining witness, the victim. Since this was set back in prior to December, I have been in contact with the officer in charge who has indicated to me that that victim no longer wishes to prosecute. I did ask for confirmation due to the seriousness of the charges and the allegations that were in the police report. And the OIC, who is Alexander Colburn, has been in written communication with me via email indicating that she confirmed the complaining witness does not wish to prosecute any further, that she is moved and will not be coming forward on this case. Therefore, the people are unable to proceed based on that information and not having a witness.
Anything from Attorney Woodside?
Your Honor, on behalf of Ms. Harris, we would move to dismiss with prejudice if she no longer wants to prosecute.
Your Honor, I'm not at liberty to have it be to not object to with prejudice. I apologize, but it will have to be without prejudice due to the fact that the people personally did not. We're going based on the officer in charge. People were not able to reach the victim, and due to the seriousness of the charges, if the victim does come forward in a few months, we want to have the ability to move forward. Therefore, we do not object to dismissal without prejudice, but we will object to with prejudice.
All right, well, based off that information, I will dismiss. It will be without prejudice. Attorney Woodside, based off of circumstances, rarely am I able to do with prejudice. In this case, I don't believe warrants that. But because the complaining witness wishes to, or does not wish to prosecute, I will dismiss. And I move forward at 1:30. Any questions?
No, Your Honor. Thank you. Will the court email me the dismissal, please?
Yes, we will.
Okay, thank you. Have a great day, all.
You too. Thanks for calling in.
Ms. I'm sorry, and I don't know if I heard this. Did you agree to allow the court to sign your name on the dismissal?
Yes, Your Honor, and I'd ask to have a bond counsel.
Okay, I will also note that in the file for the clerk to enter.
Thank you.
You're welcome. You have a good day.
You too. Hello.
Yes. Oh my goodness, thank you, man.
But we need to ready for this exam.
Right, it's a down one. February.
Oh, yeah, that's gonna get first.
Right.
Okay, I thought you were here.
No.
Yeah. Okay. All right, okay. I do have, huh? Miller? Anybody on that? Another request? Oh. This is for the prosecutor to sign. Ms. Phelps, the prosecutor stepped out. And I promise I'm gonna call your case back. There's nothing else doing the topic.
Thank you. Hello.
Ms. Johnson, you should be in courtroom 332, I believe. You have a traffic matter?
Yeah,
Yes, you should be in courtroom 332 with Judge Williams. Do you need the Zoom information?
I need the, I was in break room 4 and my phone had died.
Okay, so you need to go back to courtroom 332
Okay,
with Judge Williams. I'm not on traffic anymore.
okay,
All right, have a good one.
you too.
Yeah, all of it. You can have a seat right here. Yeah.
Ms.
Is this the
Johnson?
same one?
Yes, you, not Judge Sabree, go to Judge Williams.
Okay, my apologies.
All right. All right, so here.
record, this is People versus Henry Arthur Light, case number 096569. This is a recall set for a hearing today. Appearances.
Janelle Harris on behalf of the people, P85495.
And good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355, appearing on behalf of Mr. Henry Light, who, for the record, has been on our Zoom screen, however, is having technical difficulties, so I would waive his appearance for the purpose of this motion hearing.
Okay, and Attorney Phelps, I can attest to that. We've been trying to get Mr. Light's attention so that he could hear the hearing. However, some reason he cannot, so I will waive his appearance for today, just for the hearing. And Attorney Phelps, whenever you're ready, this is your motion, you can begin.
Your Honor, we were here yesterday on this motion, and I did put my arguments on the record. I'm happy to do that again. We put it over to today to see if the people are prepared to respond or if we need to set this out for more time. I don't know if you want me to go into my arguments again today or if you want to hear from the people.
Let's see if the people are ready to respond.
My response is going to be very limited on Ms. Phelps and Your Honor. I've been instructed by my supervisor, Liz Van Mark, on this case, as well as APA Kirker, who was handling the case prior to myself, on how to respond to the motion. At this time, the people have no objections to the defense's motion.
Thank you, Judge. In that case, it sounds like, I guess I did submit an order along with the motion for the case to be dismissed with prejudice.
Okay. I don't know, I thought this was going to be a long hearing. I should have thought this earlier. Okay, so I have the order, Ms. Phelps. I will sign it, and
Your Honor, I would just ask, because I was told to not object to a dismissal without prejudice. I honestly, I really, at this point, I'm gonna allow, I'm not gonna argue either way. I was told to not object to without prejudice. I'm not sure.
And Your Honor, oh, I'm sorry.
Oh, it's okay, Ms. Phelps, go ahead.
Oh, just the language of MCR 6.00482 does call for a dismissal with prejudice. That's the only remedy anticipated by this, and so that's what we're entitled to.
Ms. Phelps, did you say that's the only remedy or one of the remedies?
The only remedy, if you look at the court rule.
you said 6.0048. You didn't say A2, did you?
6.004D2 shall enter an order dismissing the same with prejudice.
Your Honor, I've been instructed to not object to Ms. Phelps's motion, and therefore I will refer to the court on this decision.
Okay, and I will read the court rules to the record. So 6.004, the Michigan court rules, 6.004 D2 states that the remedy, the event that action is not commenced on the matter for which request for disposition is made as required in subsection 1, which discusses periods of delay. No court of the state shall any longer have jurisdiction thereof, nor shall the untried warrant, indictment, information, or complaint be of any further force or effect, and the court shall enter an order dismissing the same with prejudice. So with that, I will dismiss with.
Thank you, Judge.
And if you want to gain over to you, Ms. Phelps?
Yes, please, Judge. And if it could also be sent to the MDOC so that they have it there and they can do what they need to do on their end.
Okay, anything else?
Nothing further. Thank you, Judge.
Okay, thank you for your patience today.
No problem.
Mr. Light, just one more attempt. Okay, Mr. Murray, we can handle your client case then.
Thank you.
Yes. You didn't ask about with prejudice.
I know. It's an old case though.
Huh?
It's a 109 case.
Yeah. Good. We're almost done. You only have 3 left. Yes, I do. And then we just have 2 for Diallo. Where's Diallo? For Diallo, we have Carter and Singleton. I have Woodside on. That's the thing's funny. There we go. Okay.
If defense going to be opposed, we have the case order at 10:30. I do have the officers have been here since 9:30. We are getting answers because they have multiple cases going on throughout 36 today. And I know Ms. Diallo's defense is here. She's been here in the courtroom. I'm not sure she just stepped out what she wants to do, but it may be.
You have
quick.
other exams?
I have another exam and
What time?
then I have to be over at Frankfurt.
This money. Your Honor, if it's something where it's not gonna be held, I was just telling defense. Well, if we could jump in first and then if it, of course, if it's gonna be held, we will not.
Okay, that's what I was gonna say. If it's gonna be a hold.
We can figure that out.
Okay. You've been here too. Okay. Yeah, we can call it.
Ms. Diallo's.
Mr. Carter, is it Carter?
Oh, yes.
Carter and Singleton.
Okay, we're on the record. This is People versus Torian Demond Carter. Number 1, case 2260240. Carter is charged with 1 count of stolen property, receiving and concealing a motor vehicle. Set for an exam. Appearances.
Morning, Honor. Danielle Parrish on behalf of People P85495.
Just good morning to you and your staff. Lillian Diallo, P52036, on behalf of Mr. Carter, who is not present.
Okay, how are we moving forward today, or are we moving forward?
Yeah. Yeah, the people are ready to proceed. All of our officers are here and are ready to hold the exam based on the information provided by the defense. People would ask for a case at this time.
Anything from defense?
No, Judge, I'm sure it's a misunderstanding.
So I will issue a case. It'll be a personal.
Okay.
With $1,000 cash.
Okay.
Thank you. All right, that was quick.
So I can sit here and wait for my next one.
All right, Mr. Mark.
Yes, Your Honor, thank you so much.
Okay. This is the people versus DeAndre Kenneth Miller, case number 2260994. Mr. Miller is charged with 1 count of police officer assaulting, resisting, and obstructing. Today is set for a preliminary examination. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
And good morning, Your Honor, Neighborhood Defender Service in Detroit, Harry Martin, P84592, appearing on behalf of Mr. DeAndre Miller. Mr. Miller, would you please state your full name? DeAndre Kenneth Miller.
Good morning to everybody. Are we ready to proceed?
Yes, Your Honor.
Any preliminary matters?
Not from the people, Your Honor.
None from the defense.
Okay, just for the record, there's no one in the courtroom to be sequestered.
No, Your Honor, had the OIC. Thank you.
Okay.
All right,
Parents, whenever you're ready to call your first witness.
thank you, Your Honor. The people call Officer Joseph Eason. Last name? EASON. Thank you.
Right over here? Yes, yeah.
Swear to tell the truth, what you know.
Yes, sir.
Okay. Have a seat, make sure you got the microphone. Whenever you're ready, Spears.
Thank you, Your Honor. Also, I'm asking a few questions, if you wouldn't mind kind of speaking to the lower line, speaking directly into the mic. I am a little hard of hearing. And to get everything ready to say. If I ask you a question that you don't understand, please stop me and I'll have to do it. Could you please restate your name for the record?
My name is Joseph Eason.
Thank you. Where are you currently employed, excuse me?
The Detroit Police Department,
And in what capacity, sir?
a police officer,
How long have you been a police officer?
almost 2.5 years.
Were you employed as a police officer with DPD on December 17th, 2022?
Yes, sir.
Were you by yourself or with a partner that day, sir?
I was with a partner.
What is your partner's name?
His name is Brian Everett.
What's the last name, sir?
Everett, no?
Were you in full or modified uniform on that day, sir?
Full uniform.
And were you in a scout car?
Yes, sir.
Was that scout car fully or semi-marked?
It's fully marked.
Did your duties as a police officer take you ever near 19255 West McNichols in the city of Detroit, County of Plain?
Yes, sir.
Can you tell us why you were at or near that location on that day?
Yes, ma'am. So my partner we were just taking a small break. He was about to go grab some snacks at the gas station.
Is that a gas station at that address?
Yes, ma'am. So,
While at or near said location, did you observe something that drew your attention, officer?
yes, ma'am.
What was that?
Also, while he was inside grabbing snacks, I observed a male driver, appears like a male driver, tumble out of the driver's seat. A female, appeared they started wrestling and arguing with each other.
Where was this vehicle and these two people that were having this altercation? Where were they at?
So they were still in the gas station parking lot.
As a result of your observation, what, if anything, did you do, sir?
I approached them, asked them, did they need police assistance? Very good.
And what was, did they need your assistance, sir?
No, no. The female said she didn't need my assistance, and the male didn't say.
Do you see either one of those people that you interacted with in the courtroom today, sir?
Yes, ma'am.
Okay. Which person is in the courtroom that you interacted with that day?
It's gonna be the male wearing the red shirt.
Your Honor, may the record reflect the identification of the defendant, DeAndre Miller? So reflected. Thank you. So the person that you pointed out in the courtroom, defendant, and just to clarify, so that we don't assume, which person was that that you observed that day?
I'm sorry, could you repeat that question?
Yeah, could you tell us in the scenario you just indicated, who was the defendant in that scenario that you observed?
Oh, he was the driver.
Thank you. Did now the driver, the defendant, provide you any information when you approached to investigate the altercation?
No.
What information, if any, did you ask from the driver or the defendant?
I didn't actually, I just asked him.
Okay. What happened after you made that first contact with the defendant?
So my partner exited the store. I guess he was advised by the store clerk that I was talking to the two individuals I just mentioned.
Officer, if you say that again, your
Yeah,
partner,
I'm sorry,
sorry,
yeah,
could
the
you
door.
speak? Yeah.
Oh,
Thank you,
yeah.
Your Honor. I'm okay with it. I'm fine with it. If
You're
you-
fine, okay, sorry about that. Okay, so my partner exited the store. I guess he was advised by the store clerk that I was talking to the two individuals I just mentioned. I was in the passenger seat. He got back in the driver's seat.
Did you observe anything after your initial contact? Or what, if anything, did you do after that initial contact?
Yes, ma'am. So I observed the male I just mentioned. He got in the driver's seat of the vehicle, turned it on. He had moved it to a parked in a handicap spot.
After you parked in the handicap spot, excuse me. Did you do anything after that?
This one, well, first prior to him, once I saw him turn the vehicle on, I ran a plate to the vehicle and then came back to register to him. So it was possibly identify him using his SOS ID.
So you personally ran the lead
Yes, ma'am.
and it identified the defendant as the owner of the vehicle?
Yes, ma'am.
You indicate that you could positively ID him. When you say you could positively ID him, did a picture or something? How was that possible?
Yes, ma'am. His Secretary of State ID that shows up with the license on.
And that was the person that you had just interacted with briefly?
Yes,
The
ma'am.
driver? Okay. What information did, aside from the registration, were you able to receive from the after you ran the plate about the driver?
Okay, I was able to ascertain that he had a revoked license.
Say what?
A revoked license, ma'am.
After learning that the defendant had a revoked license, did you, what if anything did you do based on that information, sir?
Well, I advised the partner about that, effectively stopping the vehicle after he parked in the handicap spot.
When you say you effectively stopped, did you move your vehicle or did you approach? Could you tell us how you initiated this stop?
Yes, ma'am. So like I said, after I ran the plate, he came back and was revoked. So partner drove the car around the gas station as well. Once he parks, or a little bit prior to parking, he turned the lights on.
So lights were initiated. Did you reapproach the driver at this time, sir?
Yes, ma'am.
Could you tell us about your communication with the driver once you approached after initiating the stop?
Yes, ma'am. So my partner asked him for his identification multiple times. He didn't say anything. And at that point,
Your Honor, I would object to Officer Easton saying what his partner said. And first, that it's hearsay. Second, that we don't have basis that Officer Easton actually heard this.
Officer, if you could restrict your answers to what you observed and only what the defendant actually said. So if you could provide us with what you observed and more specifically what the defendant, what you observed the defendant do or say.
And then for the record, sustaining your objection, that was hearsay. Obviously, when you stated what your partner said, that's just for the record.
Thank you, Your Honor. Did you observe the defendant provide any information to yourself or your partner?
No.
Did the defendant comply with any orders or provide any documentation to yourself or your partner?
No.
Did you observe at any time a request be made by yourself or your partner for identification or anything from the defendant?
Objection, that calls for hearsay in terms of if she's asking the observed partner to make a request.
Not asking for what he said, I just, if he observed, yeah, or if you'd like, I could rephrase, Your Honor.
Yeah, rephrase, because you can observe whether the defendant provided documentation, but observing, talking.
Could you describe the interaction that you observed between your partner and the defendant?
So you're saying, describe that interaction without saying what he said?
Absolutely. You cannot repeat what your partner said, unless there's an exception, hearsay exception. Hearsay exception that I don't hear.
Okay. So I did not observe the defendant from part of any identification.
I'm sorry, I couldn't hear that. Could you speak a little louder into the mic?
Yes, ma'am. I said I did not observe the defendant from my partner with any identification.
But as you stated earlier, you're the one who checked lane and verified that the defendant had a revoked license.
Yes, ma'am.
Did the defendant indicate to you or your partner that he did have a license or give you a license at any time?
No, ma'am.
Did he give you any information at any time, or did you observe the defendant at any time comply with any orders?
No, ma'am.
What did you do based on the defendant not complying with any of the orders?
Well, attempts to detain him based on the fact that he tried to move people who didn't have valid operation.
When you say you attempted to detain him, can you kind of elaborate on that, please?
Yes, ma'am. Asked him to turn around, place his hands behind his back. I grabbed him with his arms. He tensed up.
He did what?
He tensed up, ma'am.
Okay. Did you give him any orders?
Yes, I'm asking him to stop this.
Did he comply with your orders?
No, ma'am.
Did you attempt to place handcuffs on him again?
Yes, ma'am.
Okay. Did he resist?
Yes, ma'am.
Did he continue to resist?
Yes, ma'am.
Did you give him orders at this time commanding him to stop resisting again?
Yes, ma'am.
At any time, did he comply with any of your orders while you attempted to detain him for driving on a revoked license?
No, ma'am.
Can you please tell us how long did the defendant resist and struggle with you during this attempted detain?
I'm not sure the exact time.
Were you able to eventually detain him without assistance?
Yes, ma'am.
Can you tell me how that occurred?
So, well, before I answer this, obviously, that's what I was stating, whatever my partner did, correct?
Say that again?
That's what I was stating, whatever my partner did.
I'm sorry, I still couldn't understand.
Is that what
Well,
I-
you can pull your mask out if you.
Is that what I was saying, whatever my partner did? Because we typically work together as a unit, so you want me to just state.
Did your partner assist you in detaining him?
Yes, ma'am.
Okay, so your previous answer when I asked you, were you able to detain him without assistance? Did you answer correctly then?
Oh, no.
Okay, so, your assistance, and that includes your partner, and I apologize if I wasn't, clear. So you needed your partner's assistance to detain the defendant?
Yes, ma'am.
Okay. Can you tell me, were you able to, detain the defendant, just by giving commands, or did you have to get this? Okay, can you describe, what it took in order to get the handcuffs on the defendant?
Yes, ma'am. I'll do my reference on the report.
Pardon me?
Not reference my report.
When you say reference, can you please indicate, is there something that you don't recall?
Yes, ma'am.
Okay, so referencing your report will refresh your memory, sir?
Yes, ma'am.
Your Honor, if you could please, look through your report, please do not read from your report. Once your memory is refreshed, let us know and we'll continue with the question. Thank you.
Okay, my memory is refreshed now.
Thank you. Could you please tell us what you had to physically do with the assistance of your partner to detain the defendant after he resisted?
Okay, so I had my hand on his right arm. My partner disengaged briefly, drew his taser, advising the defendant that he would be tased if he didn't stop resisting. He didn't listen. Partner bolstered his taser, also went back hands on with the defendant, eventually took him to the ground, to apply arm lock to the defendant, his right arm, put handcuffs on.
So after you observed your partner threaten the defendant with the taser, are you confirmed he still continued to resist?
Yes, ma'am.
So after that, you had to apply additional physical force in order to get the handcuffs on him?
Yes, ma'am.
Once you were able to finally get the handcuffs on the defendant, did you have the opportunity, or did the defendant have the opportunity to indicate anything, again, in regards to his license? Did you tell him why he was under arrest?
Yes, ma'am.
Did he reply in any way after you told him why he was being arrested?
No, ma'am.
After he was arrested, did he at that time begin to comply?
No, ma'am.
Could you please tell us what happened after you arrested?
Yes, ma'am. So, after we put him in placed him in handcuffs, we were able to assist him in getting up, try to attempt to place him in the back of our patrol car. He continued to resist, refused to sit down, so we had to forcing, pushing him into the back of the cell car.
Just to clarify, did you or your partner sustain any injuries during this struggle with the defendant as he resisted being detained?
No, ma'am.
Thank you. No further questions.
Good morning, Officer Ethan. Just a few questions for me. So when you first saw Mr. Miller, it was when you approached him and his girlfriend outside their car?
Yes, sir.
And you stated that you had seen them tussling?
Yes, sir. That's what.
You said you saw Mr. Miller get pushed out of the car.
No, sir. I said they tumble out of the car.
Tumble out of the car. Okay, thank you. And at that point, you heard from Mr. Miller's girlfriend that they were all right with need assistance.
Yes, sir. I heard that she didn't need assistance. I didn't hear anything.
Okay. And after you spoke with her, you turned around and walked away, correct?
Well, after I spoke with her, I asked him to say, but he didn't say anything, so at that point.
At that, when he didn't say anything,
Yes.
at that point, you turn around and walk away,
Yes, sir.
and return to your squad car.
Yes, sir.
And at the point when you turned away, was Mr. Miller still standing outside of the car?
Yes, sir, he was still standing outside.
All right. And was his girlfriend still outside of the car?
She was in the process of walking through the store.
I see. Okay. And after this first encounter, you testified that you and your partner pulled your car out of the parking lot.
Yes, sir. So prior to doing that, I ran the plate.
You ran the plate
Yes.
prior, yes. And then after running the plate, you move your squad car and you exit the gas station parking lot.
Yes, sir. Yes, sir.
And later you return to the gas station parking lot.
So we pulled out and then made like a loop because it was the way the gas station was designed. Basically, split out, made a loop to go around.
Can you describe that loop? Was it on the closest streets, or did you have to go, a block down in either direction?
No, it wasn't a lot of concrete. It was basically just kind of around the exterior of the gas station.
All right. About how long would you say you were outside of the gas station parking lot?
It was probably a couple seconds. In the exterior, probably a couple seconds, I would say.
Just a couple seconds.
Yes, sir. Yes, sir.
And when you returned after a couple seconds, Mr. Miller's car was in a different spot.
Yes, sir. We observed him backing into the hand.
I see. So you observed the car backing in.
Yes, sir.
So just in these couple seconds that you had pulled off, the car had moved?
Yes, sir. We observed him move the car after he, like I said, started the car, ran the plate, came back to him. And at that point, he moved the vehicle, pretty much just followed him. And then he backed into the hand.
And you never saw his car driving on the road, correct?
No, sir.
It was you. Your testimony is that you saw the car driving, but it was within the gas station.
Yes, sir.
And you activated, sorry, were you driving the squad car? Or you were the passenger?
No, I was the passenger, sir.
Okay, but you or your partner activated the lights on your squad car?
Yes, sir.
And when that happened, where was his car, where was Mr. Miller's car positioned when the lights were activated?
It was back.
So after it had backed in, did Mr. Miller step out of the car?
Yes, sir.
He voluntarily exited the car?
Yes, sir.
That didn't require any additional commands or use?
No, sir.
At that point, once he stepped out of the car, you and your partner approached Mr. Miller?
Yes, sir.
Were you holding handcuffs in your hand at that time?
No, sir.
You were not?
I was not.
Were you? But at a certain point, you took out your handcuffs.
Yes, sir.
About how long after seeing Mr. Miller did you take out your handcuffs?
I'm not really sure on that.
Less than 20 seconds after seeing him?
I'd say that's about right. That's about right.
Maybe even less than 10 seconds after seeing him? You pulled out your handcuffs?
I'd say less than 20.
And you yourself were not asking Mr. Miller for his license. You didn't ask him for his license when you first walked out, did you?
No, sir.
You didn't ask for his registration or his insurance?
No, sir.
what were the first words you remember saying to Mr. Miller? As you approached him that second time?
The first words I recall saying to him was, do you hear my partner talking?
Oh, do you hear my partner talk?
Yes, sir.
Is it possible that the first words you said to him were, "Don't tense up"?
Those are not first words I said to him.
Not those. At any point, did Mr. Miller ask you the reason he was being arrested?
Yes, sir. Well, he asked my partner.
He asked your partner. And he asked because he had not yet been told the reason he was being arrested. As far as, did you observe him being told the reason for his arrest prior to that?
Prior to him asking.
Prior to him asking.
Can you rephrase that question?
Yeah, so you stated that you heard Mr. Miller ask, "Why am I being arrested?" And before that, did you observe Mr. Miller being told why he was being arrested?
Actually, yes.
Yes, what did you observe?
Well, obviously, you said I can't say what my partner said, but
I understand. I'm asking for it, right?
okay, so my partner pretty much asked him, where's identification? He didn't say anything multiple times. Attempted to detain him for obviously not having a valid operating permit on this person. And then eventually, after we arrested him, he told him that he was arrested for not producing a valid operating permit.
And so, so that conversation you just described, did that take place in the under 20 seconds before you pulled out your handcuffs?
Well, the first part of the conversation did, because eventually he asked for his identification. That's what led up to the whole use of force. So first thing he asked for was his identification times. And then the second part happened subsequent, because he basically told him that it was just normally NOP or driving with a license, no ticket, but because of the use of force.
So it's fair to say that it wasn't until after you pulled out the handcuffs that he asked, "Why is he being arrested?"
Yeah, that's true.
Yeah. And so it wasn't until that point that you observed him being told the reason for his arrest.
Yes.
At some point, did you tell him that he wasn't supposed to be driving?
I did not tell him that. But would you, in this case, it occurred to me that hearsay exception, because.
I didn't hear what you said about hearsay.
It occurred to me hearsay exception, because I didn't say.
I'm not objecting to it since defense is asking.
Okay, sure. Yeah, I heard my partner.
That he's not supposed to be driving?
Yes.
Do you know whether Mr. Miller was ever told the specific status of his license? Like, was he told that his license was revoked, or was he simply told you're not supposed to be driving?
Oh, he was just told. He wasn't told his license.
He was not told his license was revoked. And was there someone else at the scene claiming that they were the one who was driving?
Yes, sir, it was.
Yes. Was that Mr. Miller's girlfriend?
Yes, sir.
She claimed that she was the one driving.
Yes, sir.
She said that multiple times?
She did.
No officers were injured in this incident?
No, sir.
And Mr. Miller was, after a few minutes, gotten in handcuffs and in the back of the squad car?
Yes, sir.
And after that, he was transported without incident?
It was another incident that occurred subsequent to him leaving our scout car. But it was kind of minor.
Oh, but nothing made. No. You did not observe any additional incidents once he was inside the squad car?
My scout car or?
Your scout?
No, I did. That's what I was doing.
And you testified that you found his license status through a lien search.
Yes, sir.
Do you know if the record of that lien search is available in court today or was provided to the prosecution?
Objection, Your Honor. Defense knows that these cannot be provided. As we know, it's a felony for us to actually provide lien results on a defendant to anyone. So we do not provide it, nor do we ask others to provide it. But I believe the question, however, is allowable. And then redirect you to verify. Thank you. Based on the
As far as you know, the lien results themselves were not provided to the prosecution in this case.
As far as I know, I don't think they were.
I have nothing further. Thank you.
redirect. Yes, thank you. Just a couple questions to clarify based on the information right after the cross officer.
Yes, ma'am.
Did you, and I know you said it, but I just want to be very clear. Did you actually see the defendant driving as he parked into the handicap spot?
Yes, ma'am.
So you actually saw him in the driver's seat pulling into the park? Okay, so it wasn't like you just saw the car, you saw him? Okay. All right, so also you indicated during cross that the defendant, I just want to clarify, was told he's being detained for not providing a license or having a license on his person at that time?
Yes, ma'am.
So he was at that time detained. So is that, and you also indicated that you heard multiple times the defendant not provide a license after being requested for one, after having being requested by your partner?
Yes, ma'am.
After that, is that when he was told that he's being detained for not having provided a license or having a license on person while driving a vehicle?
Yes, ma'am.
At that time, is that when you pulled out? And I'm just trying to get the timeline because I know the questions were asked a little bit differently. But is that when you pulled out your handcuffs?
Yes, ma'am. Once I realized my partner was detained.
So he was already told that he was being detained for not providing the license?
Yes, ma'am.
Okay. And just to clarify, you did verify via the lane system after he was arrested. And I understand you indicated that he was arrested for R&O on top of that, but just to clarify, you were initially detaining him for not providing a license.
Yes, ma'am.
Did you verify on lane that the status of his license after doing so?
Yes, ma'am.
Okay, and what was the status of his license?
It was cool.
I know defense asked you this, and my apologies, because it seemed like you may have been a little confused by the question in your answer. So if I may just ask it a little bit differently. After you arrested the defendant, placed him in your vehicle, did you observe him after placing him in your vehicle, resist any further?
Yes, ma'am.
When was that?
So, for our use of force, we don't obey the detainee that we use force on.
Say that again, I'm sorry, did you say that?
Yes, of course. For our use of force, we generally don't convey the detainee we use force on in order to de-escalate or ameliorate the situation. So we had another scout pull up to convey him to the center. After they pulled up, we were able to have him next to the vehicle, and I assisted them and place him in the back of their patrol vehicle.
So you actually had to remove him from your vehicle after placing him in your vehicle and place him into a different scout vehicle?
Yes, ma'am.
Okay.
And then prior to him going in that scout vehicle, another officer asked him to sit down multiple times, he didn't, so had forced him in that vehicle as well.
So, did he, without resisting, enter the second scout vehicle?
No,
Okay, so he resisted during that time as well?
yes, ma'am.
Did you have to forcefully place him into that vehicle as well, or observe someone else physical to place him into that vehicle?
Yes, ma'am.
Was it yourself or someone else that had to do it?
It was myself and someone else.
Okay. So it actually took multiple people, again, to put him into the vehicle?
Yes, ma'am.
No further questions, thank you. No further questions, Your Honor. Okay. I'll leave you are safe to put that down. Any other way to tell people? I believe people are right. Any way to this judgment?
None, Your Honor.
Thank you, Your Honor. People move that DeAndre Kenneth Miller be bound over on count one, police officer assaulted resisting or obstructing. As the testimony from Officer Joseph Eason indicated, the defendant, after was approached due to the fact that he was observed by the witness who testified, driving a vehicle, parking it into the handicap spot, the defendant, which he identified, driving the vehicle. Also, the officer indicated that he himself ran plates that verified that the car was registered to the defendant and that the registered owner was the defendant, and indeed the defendant had a revoked license. This provoked the officers to go and investigate further. The officer testified that he observed that the defendant at no time complied and provided a valid license. After being asked multiple times, he never gave a license. During cross and my follow-up, the officer also confirmed that the defendant was told why he was being detained, that he did not provide a valid license or have a valid license on his person while driving this vehicle. Then, when they were detaining him or attempting to detain him, he resisted not once, not twice, as was testified multiple times, to the point where one officer had to pull out a taser. He continued to resist. Then the other officer, that actually testified indicated he had to get physical, and eventually it took both officers' efforts to put the handcuffs on him. Up to now, the testimony indicated him obstructing the investigation, not providing any information, and then once being detained and told why he's being detained, he resisted continuously. After being arrested and put into the vehicle, he continued to resist. So regardless of him questioning why are you arresting me, he was told that he's being detained because he did not provide a valid license. There is no question here that he ever provided a valid license, that he ever tried to indicate that he had a license, or that the detaining or arresting this defendant on those, on that was invalid. He just apparently did not feel that that was a valid reason to arrest him, and he resisted the entire time. Therefore, the people have shown probable cause. As far as the other facts of the case, we believe, whether he was driving on the open road, whether he was, all of this is a question of fact, but people believe that they have met their burden of probable cause and ask that he be found over on count one. Thank you.
Your Honor, we would object to bind over with just brief argument. Resisting and obstructing, while it can include simply not following an order. This is a statute that's meant to protect officer safety. And what we're talking about here is an incident where an individual was stopped for driving a short distance within a parking lot, allegedly, and was was brought out of his car, stepped out of his car voluntarily, and within 20 seconds, while he's still confused about the reason for this stop, is being placed in handcuffs, told he can't drive without hearing the specifics of why that is. He was panicked, he was anxious, and he did not act in a way to injure officers. He was just very upset and worried and confused about the reasons for his arrest, and repeatedly asked, why is he being arrested? Meanwhile, his girlfriend is standing by saying that she was the one that's driving, which casts doubt on the reasons for the arrest and should have been dealt with some further investigation. This is a disagreement. What happened here does not rise to the level of felony. We would object to a bind over on this. Thank you.
No, Your Honor, people still believe they've met probable cause standards. Thank you. Okay, the court has heard testimony today from Officer Joseph Easton from Detroit Police Department. And he was also with his partner Ryan Everett, also with DPD. They were in full uniform and scout car fully marked. Stated that they were taking a break and grabbing a snack at the gas station, in which Officer Easton observed the defendant tumble out of the driver's seat of his vehicle, and that he was with his girlfriend and they were tumbling in the gas station parking lot. Officer Easton stated that he asked if they needed assistance. The defendant did not state anything, and the woman said no. Officer Easton then said that he observed the defendant get back in the vehicle and move the vehicle to a handicapped spot. At that point, he ran a plate, and via lean, he was able to determine that the defendant did not have a valid driver's license, that was revoked, and also matched the defendant's face with the Secretary of State picture showing that he owned the vehicle. That would be the defendant. At that point, Officer Easton's partner was back outside, and they drove the vehicle, their police officer vehicle, to the defendant, towards the defendant's car, and initiated the lights. And there was testimony revealed through cross as well that the defendant was asked if he had a driver's license and asked for documentation, and the defendant was unable to provide that documentation, in which this Officer Easton pulled out handcuffs and attempted to detain the defendant, and that is when the defendant began to resist. The testimony, a little confusion as to the questions asked. I believe Officer Easton didn't understand some of the questions. But what I'm gathering is that Officer Easton tried to place the defendant in handcuffs, that he resisted several times. Then he eventually detained Mr. Miller with the help of his partner. Excuse me. And that during that time, Officer Easton's partner at some point advised the defendant he was tased if he did not cooperate. So I cannot change the law. The law as it is in Michigan, it is a misdemeanor, criminal misdemeanor, to operate a vehicle without a license. My opinion on that law doesn't matter here. But that's what it is. And based off the testimony, I believe people have met their probable cause standards, that Mr. Miller, after not providing proper documentation and after trying to be detained by Officer Easton and his partner, did resist and obstruct from being arrested. And I just said it again, I don't necessarily agree with not having a license being a criminal misdemeanor, but it is. And based on that, I'm going to bind the defendant over to Third Circuit Court for an arraignment on information. And his arraignment on the information date will be February 1st at 9 o'clock.
I asked for a different date for that.
I can't get the scheduled date 2 weeks out.
I can try to. Thank you, Judge.
Thank you.
I think I'm doing it.
That's him?
Uh-huh, that's him.
Okay, great. Oh, wait, he's connecting his
Morning.
audio.
Video's that.
No.
Thanks.
Hello, are you able to hear me?
Yes, all right, is your name, Paul Singleton?
Yes.
Okay, you're checked in.
Okay.
Yes, please.
Okay. Okay, this is the People versus Paul Singleton, case number 2260098. Mr. Singleton is charged with count 1, home invasion, first degree, count 2, assault with a dangerous weapon, felonious assault. Today's set for a preliminary examination.
On behalf of the people, P85495.
Judge, good morning to you and your staff, Lillian Diallo, P52036. On behalf of Mr. Singleton, who comes to us through Zoom technology with consent and apologies for the mix-up, not being here in person.
Mr. Singleton, can you state your full name for the record, please?
Paul I. Singleton.
Thank you.
Okay. Now you say apologies.
Right, so Judge, I was able to reach out to Mr. Singleton. Mr. Singleton, texted me back to, give him the phone number, which I told him I don't have that. That's not what Ms. Diallo does. So Mr. Singleton, you can stay still for 1 second. At this time, Judge, we are ready to proceed. In this case, my understanding is the government is not ready. That being said, we would ask for a dismissal without prejudice for whomever's on the screen. I see a brick wall. Mr.
Singleton, can you stop moving, please? Your attorney, me, everyone. You're gonna make us dizzy. Just stop for a second, please. Thank you. This is important. It's enough for you to stop and just pay attention. Okay. Anything from the people?
Defense is correct. At this time, people are not ready to proceed. I spoke to the OIC, requesting some additional information in regards to evidence as well as victim contact information. And we do not have it at this time, therefore we have insufficient evidence to proceed at this time. And this has been, Your Honor, just so that I don't minimize the efforts here from the prosecutor's office. These attempts to get this additional information and get the file in order have been going on since the end of November. I do realize. So it has been going on for some time, but unfortunately, the people have not been provided any additional information that they've requested from prosecution, or excuse me, from the officer in charge. And the officer in charge indicated to me via email yesterday that at this time, they do not have the evidence needed to go forward. If that is later provided, Your Honor, we would reissue.
Okay, anything from the bench?
No, Judge, we would make the motion to dismiss without prejudice.
Okay, based on the information provided by the people, I am going to dismiss without prejudice. Mr. Singleton, your case has been dismissed without prejudice. As the prosecutor stated, they said they will reissue, but they have the right to. And you won't know that unless you are notified of charges. But at this time, your case has been dismissed.
Are you wearing a tether, Mr. Singleton?
You have to unmute your device. I'm muted.
No, ma'am.
Thank you. Thank you, Judge.
I have one question. Will I be able to pick up my firearm?
Good. Now, look here, Mr. Singleton, that's a horse for another day. You can petition, you can go to and see if they will release that firearm to you, okay?
Okay.
Goodbye.
All right, bye-bye.
Bye.
Thank you.